My name is Babs Akinyoju, and it is my privilege to host this event. I previously served as the BNLF chair from 2009 to 2015, and I have led the family law and criminal law networks respectively since 2018. I'm a dual qualified lawyer in England and Wales and Nigeria. My day job, I work as a consultant solicitor with Setfords, where I specialize in children's law, criminal litigation, and professional misconduct. So tonight, the focus of this webinar is on international aspects of law, practice, and procedure in respect of children. We have two eminent speakers who have kindly agreed to share their knowledge and perspectives with us. We have Dr. Omolade Olomola, a professor and head of department, private and property law at the University of Ibadan. She is also the alternate director of the Women's Law Clinic. Professor Omolade's expertise spans family law, child justice, gender justice, clinical legal education, reproductive health rights, international human rights, disaster management, and forced migration. She has authored and co-edited several influential publications, including Family Law and Succession in Nigeria. And in fact, I'm the proud owner of a signed copy, which I obtained from her when we met last year in Ibadan. Our second speaker is Maria Wright, PhD. Dr. Wright is a senior associate at Hunter's Law. She specializes in children's law. She is nationally recognized as an expert in international parental child abduction. She regularly represents parents in urgent high court proceedings under the 1980 Hague Convention, and also the alternative procedure that deals with countries that aren't signatories of the Hague Convention, of which Nigeria is one. So that is under the inherent jurisdiction of the High Court. Dr. Wright is a founding member of the Child Abduction Lawyers Association. In 2023, she was awarded her doctorate at the University of Bristol for empirical research into child protection in an international context. She is the author of a book published by Bloomsbury in 2025 titled Care Proceedings with an International Element, an Empirical Study. And that brings us nicely to, if our hard topic this evening is about overseas placement of children in the family court. Each speaker will make their presentation for a duration of 20 minutes. Then that will be followed by a Q&A session. So there'll be the opportunity to react with them, put questions and comments. So if you have any questions, please, burning questions as we're going along, you can put them in the Q&A box and we would get to them. Following the formalities, we'll hear from the BNLF Social Secretary Fumbi Kinsoya, and she'll inform us about future BNLF events. So we would conclude this event by 7:30. Before we hear from the speakers, may I invite Katie Dean, who is the business development lead at Our Family Wizard, to tell us more about the parenting app. Thank you, Katie.
A moment. I've just shared my screen just to check. Can you all see that first slide? Perfect. Well, thank you so much for inviting us to join today. Some of you might be familiar with Our Family Wizard, but for those who aren't, we are a web-based co-parenting platform, which is just a fancy way of saying we are an app, and we are a website designed specifically for communication between divorced and separated parents. Our Family Wizard is available globally. We started out in the US 25 years ago, so we've been running around the same amount of time that BNLF has been running. We started in the US, but we've been in the UK for the past 7 years, and we have a sort of separate UK entity here. So any sort of moderations that have been made here are primarily around sort of data compared to the US, but sort of 95% of the platform is very much the same in the UK as it is in Australia, Canada, and New Zealand. We are launching across more of Europe in the next year, starting with sort of Spain, Ireland, and France. We have versions of the platform coming out this month in French as well as Spanish, and those versions will be available globally. But we are sort of launching a new sort of Euro push as well this year. The main USP of our Family Wizard is and always has been accurate records and accountability. We don't allow parents to delete or edit messages after they send them, so it is sort of enforcing that clear record of exactly what had gone on. If it was sort of needed to be depended on later on, we have those reports available. And those reports can be downloaded by parents or they can be downloaded by a connected professional. That can be a legal professional, mental health practitioner, social worker, basically anyone working with that parent in a professional capacity can connect using professional access and actually then oversee their client's activity and download reports directly from us. All of the features are very much designed to have a solution focused style. So if there are issues or things that need to be exchanged in the calendar or in the expense log, instead of sort of having a back and forth discourse, they can make a request, send it over, and it has a yes no sort of answer format. So it's trying to minimize the back and forth and the noise around what can be quite a simple solution a lot of the time. We are a paid platform, so it works out £107.99 per parent per year for our sort of normal essentials package, which is what most families will be using. That is the equivalent of £9 a month. We don't have an option for parents to pay monthly. We have a 30-day money back guarantee always. So if they sign up and they don't like it, they can always get their money back in that first month. But for anyone who can't afford £107.99 in one go, we have our fee waiver process available, which can be applied for by parents on legal aid, universal credit, any kind of government benefits, etc. Or a professional can apply on behalf of that parent as well using our fee waiver form. The other two sort of pricing options vary primarily down to how they use our calls feature and file storage. So premium, they have unlimited call time and unlimited file storage. That essentials, they get 45 minutes per parent per month of outgoing call time. So if they are both on essentials, that's actually 90 minutes a month in total, as well as 5 GB of file storage. That isn't contributed to by messages or calendar changes. It's just if they're sharing sort of photos, videos, or larger files with each other that they might eat into that a bit more quickly. The final step up is our Max package here, which gives the option to have recorded audio and video calls. With our recorded calls option, we do need explicit two-party consent every single time a recorded call is initiated. It's not something they could accidentally leave switched on and then not realise a call is being recorded at that point. They do sort of have to give their consent every single time. So it can be sort of an alternative to supervised video contact, wherein that professional might not always be able to be on that call at every time, but they could watch it back at a later date if necessary. With our fee waiver, it does outline here in sort of step 2 the kind of evidencing a parent can apply with on their own, so job seekers allowance, legal aid, any sort of universal credit, and there's actually a sort of digital form on our website they can use. This form here is where a professional might fill it out on behalf of that parent, and that would be step 1. And then step 3, step 1 is just the information we need to set the account up. Step 3 is a bit of information about yourself, the professional, where you can sign verifying that in your professional judgment, this parent can't afford us right now. It is designed to extend to the remit of the fee waiver to circumstances that we know are happening. So Perhaps there's been a history or allegations of economic abuse and they can't access certain bank accounts right now, or perhaps at the end of quite contentious financial proceedings, they might have a fair bit of money, but right now there's no access to any of it. We know that's happening. We're more than happy for you as the professional to fill it out on behalf of that parent. It works on an annual basis, but it's not capped at 1 year. So the same way someone would renew their payment at the end of the year, we just need that form filled out again on that annual basis. We also have a forces discount here. So this is for any current or veteran members of the police or armed forces, and it works out as a 2 for 1 of the essentials package. One of our most recent feature updates is Tone Meter and now the AI version of Tone Meter. The AI version is optional. We are not going to force the use of AI on anyone who doesn't want to use AI. If they don't opt in for this, they will still benefit from the functionality of Tone Meter that we've had for several years, which gives tone analysis. It picks up on negative language the same way a spell check might pick up on a spelling mistake. It's going to flag it up, but it's not going to stop them sending that message or filter the language. So parents do still have autonomy and control of what they choose to send. The AI version, if they do opt in for that, they have this suggestion mark where they can actually have that message rewritten for them in a clearer, calmer way. The model of AI that we use is built by our developers. We are not sharing parent data with ChatGPT or Gemini. It's very much our secure circuit, but it's also purpose built. It's not going to paraphrase an insult in a less insulting way if there's nothing of substance or purpose in there. It's going to pick up on things that need to be communicated and find a way to communicate them more effectively. With our calls feature, it works over the internet, so there doesn't need to be sharing of phone numbers or email addresses. It also works on a consent basis, so parents can toggle their consent off if they don't want calls coming through at certain times of day. We do timestamp anytime they press a button, regardless of whether they're using the recorded calls option or not. So you'll have a very clear record if they're only opting in between 5 and 6, but also if they had a 5 o'clock call scheduled and at 4:59 they toggled that consent off. That is documented as well, so it's an extra tier of transparency that you don't always get if they block the other parent's number on WhatsApp. And then with the recorded calls, there is a second tier of consent that we need. So if they do initiate a recorded call, they would answer it in the same way, but they don't see or hear the other parent until they respond to this notification, where they have to outline that they are consenting to that recording. They can always leave the call if they are not happy with it taking place and go and initiate an unrecorded call. But if they do then continue with that call afterwards, they can download a activity report, which is available for both recorded and unrecorded, but also they have the option to download a transcript. With the call reports, so even if they're not using the recorded option, we do have timestampings of who initiated the call, who ended the call, if they mute themselves, unmute themselves, etc. And then with the transcripts, they are really accurate at picking up what was said. They can transcribe in multiple languages as well. So if you do have parents that sort of flip between English and French mid-call, the transcription will just be in French. What it doesn't have is voice recognition. So it does outline here that names of speakers are assigned by device and it is time-stamped. So if two people were speaking through Taylor's phone, you can always cross-reference with the recording and see who was speaking at 20 seconds in. We are fortunate enough that we are court-ordered in England and Wales almost every day these days. And we have got an order language template that was written for us originally by His Honour Judge Martin Darcy, who was previously head judge in Bournemouth. We've since had this updated to include newer features. He wrote this about 5 years ago. And a few highlights to this: you can add a deadline, so within 10 days of an order gets the ball rolling. Making communication regarding child arrangements exclusive to the app, so things can't be edited or deleted elsewhere. Specifying use of certain features, so calls should or should not be recorded, and actually then limiting messaging. So try and use a stripped back yes no format in the calendar or the expense log. If you absolutely cannot convey that message in that style, then you have messaging with the tone meter as a backup there, as well as outlining professional access and costs. If anyone would like a copy of this afterwards, I'm more than happy to email a version over. A few extra additions for 2026. So I mentioned earlier that we have French and Spanish coming very, very shortly, with German shortly after that as well. We also have calendar integrations, so parents will actually be able to view their own personal or work calendar alongside a parenting schedule in our calendar. We have free professional webinars lined up, including our next one, which will be the launch of the Separated Parenting Program Directory. So this is a new charity that we are working with, who will be sort of running our next webinar, as well as improvements to professional access. So we are improving the professional accounts that we offer as well. That is everything from me. And that actually is me to finish with. Our slogan is better co-parenting, happier children. So we finished with at least one happy child. My email is there as well as my number. If anyone has got any questions afterwards or later on this week, please feel free to send them my way. I'd be more than happy to send over some more information. Thank you very much.
Thank you very much, Katie. If we do get any questions that come through here, I'll pass them on to you.
Thank you.
Yes, and I look forward to seeing the launch of this in in one of the African countries to start with. Yes, but thank you very much. Yes. So, if we can now proceed to Professor Olomola's presentation, please. I think she's got the slides.
Okay. I hope I'm audible.
You are audible. I think we're just getting the slide to the beginning.
Okay. And it's moving. Is the slide moving?
It's at number 23 at the moment.
Okay.
Right. Yeah, we've got it to number 1. Are you able to view it? Can you
Yeah.
see it is at number 1 at the moment?
Yeah. Yeah.
Yes. Okay. Thank you.
And is it moving as I'm moving the cursor? Is it moving?
It is moving.
Okay. So good evening once again. So to talk on the Nigerian family justice system, the overview. Um I'm going to start the discussion from the Matrimonial Causes Act because it actually marked a significant turn, you know, in Nigerian family law, and it established a legal framework for marriage, divorce, and related matters. And of course, the act facilitated various coexistence of various marriage systems. In Nigeria, we run this pluralistic system, the common law, the Islamic, the customary, and the family justice system is structured to address a range of different disputes through the family courts established under the Child Rights Act. I need to say that because in time past, our law had been with before the pre 2003, before we had the Child Rights Act, it was this MCA that we were using, and the pre MCA, which made a turning point, the initial turning point, we were running the fault based, until 1970. So family courts in Nigeria handle wide variety of different disputes, and our family courts, unlike some jurisdictions that particularly have children's courts, we have family courts, and family court deals with everything and anything that would have to do with the family inheritance, domestic violence, protection orders, and different complexities, maintenance, and what have you. So like I said, it's a plural framework. It talks about the statutory, the customary, and Islamic law, and that creates some dynamic challenges for us. And because the type of marriage contracted actually determines the court, determines the speculation of the law. It determines so many things. And when we talk about the family justice system, he talks about the custody, the maintenance, the domestic violence and adoption. And I must say that with the Child Rights Act, the child justice system in Nigeria is gradually growing. And apart from the family courts, we have the Islamic courts, the Sharia courts, and the customary courts. Like I said, these courts handle legal issues related to marriage, divorce, inheritance, based on that particular system, which is Islamic or customary. And the Child Rights Act protects the rights of children in Nigeria, ensuring that they are treated fairly. And this law covers child custody, maintenance, abuse, issue of neglect. And I would want to say that the Child Rights Act, the way it came in as a law, it was enacted by the National Assembly. So it didn't, so each state of the federation had to reenact it as their law and domesticate it. And it had been back and forth for several years until 2024, when the last state, which happened to be Bauchi State, eventually enacted the law. But the challenge is that out of the 36 states, 11 states are yet to gazette this law. And it's because, okay, let me just continue my discussion. When we get to the Child Rights Act, I'll be able to explain that reason. So the key objective of the justice system in Nigeria is to enhance access for the vulnerable population, particularly the children and women. And the family court is designed in such a way that the procedure is simplified, not like the regular intimidating court environment, though we have family court at the magistrate level and we have it at the high court level. The previous law that was enforced, the Children and Young Persons Act, served as the primary statute governing child justice administration, and it had some outdated views on childhood and legal responsibility. But having family courts have been able to improve on what used to happen under the juvenile court. The courts have now been reconfigured into family courts, and they prioritize the physical, emotional, and psychological well-being of the children. And the establishment of this court is pursuant to the Child Rights Act. It marked a significant turning point in addressing the complexities of family-related issues involving children, and these courts were designed to handle matters like custody and maintenance and the other things. And, the courts emphasize on the issue of training and people that are knowledgeable in child's rights. And like I said, it operates, as court division on 2 levels, at the high court level and at the magistrate court level. And this dual structure allows for a more flexible approach to addressing family-related legal issues. And with magistrates specially trained to deal with child welfare matters, prioritizing custodial decisions over broader matrimonial disputes. And in time past, you may not be able to quickly get custody or withdraw a child from a dangerous situation. You have to wait till the matter is taken to court under divorce or what have you. But nowadays, with family court, you can apply directly, to the court to withdraw a child from a particular setting to a safe setting. And it's a great improvement on what we used to have, because you don't have to have a matter in court pending or a matrimonial proceeding, a matrimonial court proceeding pending before a child could be taken care of. Now, looking at our framework, of course, the Constitution mandates protection of children in Nigeria. We have the guarantee fundamental rights, though they are not child-specific, but they are enforceable rights within family justice processes. But this Child Rights Act that came in is the principal legislation governing children's rights, and it defines a child as a person under 18. Now, I need to say this. Under this the CYPA, the previous law, there were different levels of age age of criminal responsibility, age of this, a child that is below 14 is not below 7 cannot be criminally responsible. A child that is, and different, and it creates some confusion. But this confusion has been laid to rest. by virtue of the provision of the Child Rights Act. Albeit, I believe that there can still be some improvement, because just judging a child by the age may not actually do the excellent work, because you might need some forensics at some level, because at some children may not mature with their age, and but that's a business for another day. But a child is currently a person below the age of 18, and the Child Rights Act establishes the best interest of the child as paramount. It provides for custody, guardianship, adoption procedure, foster care, child protection, and it creates family courts at the state level. Then it also establishes best interest as being paramount for all actions concerning children. And that is the central test for all family courts in Nigeria, which is similar to UK standard anyway. And sections 149 to 158 create this specialized court at the High Court and at the Magistrate Court level. And of course, they have exclusive jurisdiction over child matters. Now, I need to point out some key provisions of the Matrimonial Causes Act that relates to children, because every matrimonial proceeding would go on with this law. And of course, matrimonial proceedings involving children, they will have to mention something about the welfare of a child, custody of a child, maintenance, financial support for the children. And of course, this Matrimonial Causes Act prescribes that the welfare of the child should be the paramount consideration for custody decision. It's not a matter of the father owns the child in line with our patriarchy system, the best interest principle, and this follows the best interest, it aligns with the best interest principle of the Child Rights Act. Then section 69 to 61 talks about the issue of custody, care, and control, talking about access, visitation rights. And this is also in line with the position of the Child Rights Act that says that a child should not be kept where that child will not grow up to be a balanced human being. They're talking about maintenance and financial support for children. It's covered by section 70 and 72, where the court may order either parents to provide financial support covering education, welfare, and general upkeep. And maintenance can also continue after divorce. And this is similar to what is provided for under the Child Rights Act. Now, I need to say that our Child Rights Act follows after international legal instrument, the United Nations Convention on the Rights of Child, 1989, and the African Charter on the Rights and Welfare of Children, 1991. And because this instrument actually emphasized child protection, participation, and right to survival, and it has really influenced judicial interpretation and legislative reforms. And the core provisions, which are very key to allow the best interest of the child, which is under Article 3. This best interest of the child is a primary consideration. Apart from it being a procedural rule, is a substantive rule, which must be followed, and best interest is very wide, highly subjective. It's a case-by-case analysis. It depends on each child. It's not that a child coming from a very humble background expecting the parents to now provide something bogus. No, the child would be adequately taken care of, and the court will look into it. Then the issue of separation from parents in Article 9, children should not be separated from parents except where necessary, where there is abuse or neglect. There have been situations where children are taken away from parents to family members, to foster care, because the parents have been abusing that particular child. Then another beautiful thing about the Child Rights Convention, which is in our Child Rights Act, is the right to be heard. The children have right to participate and express their view in things that affect them. Culturally and traditionally, it is believed that a child is supposed to be quiet, when elders are speaking. And children grow up with this idea. But now from the law, children have the opportunity to participate in what actually affects them. And they're also protected from abuse, from neglect, from exploitation. The Charter on the Rights and Welfare of the Child. This document is Africa specific and is very important to us in Nigeria because it reflects our local Rarely it is. And the core provision is also best interest principle. So whether we like it or not, best interest is something that we must actually take note of. Then parental care protection, it talks about family responsibility and state support. Parents having primary duty and states intervening where necessary. Well, we are gradually improving. I would say that our system is not yet as mature as what we have in some jurisdiction, but the state is gradually intervening, but there's still a lot more to be done, a lot more, because some children are still in situation where the states need to intervene and the states is not intervening. Maybe there's lack of reportage, or the reporting system is not as developed as it should. Then talking about harmful cultural practices like child marriage, harmful traditions, we still have it in some places, which is disheartening, and a lot of awareness is still going on, and the government is have legislated against some of these practices, although it's still being practiced in a hush-hush manner in some communities. Then children of imprisoned mothers, desiring special protection for children in such situation. The child justice system in Nigeria and UK aim to protect welfare and rights. Yes. Of course, the situation in UK is more developed, but Nigeria will face some significant challenges in different forms and degrees. And I know both jurisdictions are influenced by the Child's Rights Convention, the United Nations Child Rights Convention. And in response to this, we have our Child Rights Act, and of course, the UK, they have their laws. The Scotland, they have the Care and Justice Scotland Bill, and other relevant laws. Both countries, there is a pressing need for robust legal protection for children involved in the justice system. And recent amendment to the Criminal Justice Act in UK reflects that commitment to safeguarding the rights and welfare of these vulnerable individuals. And these changes aim to ensure that children's voices and rights are upheld through legal proceeding and having a more responsive and accountable system. Now, there are a lot of challenges facing child justice system in Nigeria. Children within the family justice system face complex legal, institutional, social, cultural difficulties, and this actually prevents the full realization of their rights in spite of the constitutional and statutory protection provided by the Constitution and the Child Rights Act, and of course our obligation under international law. Now, picking these issues one after the other, talking about weak implementation of child protection laws, we have conflicts between the different legal systems. I'll still discuss them. Limited recognition and application of best interest principle, inadequate child participation in proceedings, delay in family justice proceedings, poverty and economic vulnerability, weak enforcement of maintenance orders, domestic violence and family breakdown, cultural silence around child abuse, limited specialized family courts, inadequate social welfare infrastructure, and child marriage and harmful traditional practices. Talking about with implementation, though we have enacted the Child Rights Act, the implementation, like I mentioned earlier on, remains uneven because not all states have fully domesticated it. In some jurisdictions, the custom, the religious don't continue to override statutory protection. And this is so because of the type of system we're running. You could be married under the customs, you can be married under your religion, you can be married under the statute. And so this conflict between this legal system creates serious uncertainty for children because the statutory law may prioritize the best interest of the child, but customary law may prioritize lineage, paternal authority, or communal interest. You see? Islamic family law may apply different standards in custody and guardianship matters. This conflict often produces unequal outcomes depending on the forum where the dispute is heard. So you can imagine a child the matter is taken before a customary court will not have may not end up with the same decision with a child that is in a statutory setting. Then limited recognition and application of best interest principle. The principle that the welfare of the child should be paramount is often stated but not consistently applied in practice. And courts may still prioritize parental claim, family reputation, patriarchal inheritance expectation. As a result, children's voices are rarely independently heard in proceedings affecting them. They make all the decisions, they make all they make all the findings, and the voice of the child is left out. Then inadequate participation. They are excluded from final decision. Where do you want to stay? Although some take the children's interest into consideration, but most of the time they participate like not participating. They are there, issue of relocation, care arrangement after divorce. And so in many family court, there are no specialized child interview mechanism or trained child psychologists. This is a fallout of our system. And delay in family justice processes. Family disputes involving children often suffer prolonged delays, and it affects maintenance claims, custody orders, paternity determination, protection from domestic violence, and delay can expose children to prolonged instability and emotional harm. At times, like I said, children would have to wait endlessly. The children are with the mother. The mother is just a small scale businesswoman trying to maintain her life. She cannot bear all the financial responsibility, and the man is waiting for the court to make pronouncement that he must have custody before he pays any money. And this delay exposes them to instability, and some children will actually stop schooling because taking them to court every now and then, and some men could file, in a family court that is very far away from where the woman is residing, just to punish the woman, not knowing that in punishing the woman, the children that are with the woman would also suffer. Then the issue of poverty and economic vulnerability. It's a major issue. Economic hardship significantly affects children's access to justice, and many parents cannot sustain litigation costs, leading to abandonment of maintenance claims. Children from poor households are disproportionately disadvantaged. If the two parents are well-to-do or are comfortable, maybe a different story. But a situation where maybe a man wants to show that he's the man and wants to deal with the recalcitrant mother, most of the time, the children would suffer and suffer, and that's why I said our system is still evolving. Then weak enforcement of maintenance order. I was in a workshop, and somebody asked this question that he has been noticing that courts grant child maintenance, but enforcement actually remains difficult because there's, apart from absence of reliable income records, you don't know when the man is earning so much and his claiming is earning so little and is not verifiable. There's nothing that can be done about that. Then non-compliance by parents and weak enforcement. The father is supposed to bring some amount of money to the woman regularly. He's failing. He will bring one in 3 months, and the court have to call, threaten, arrest. I see that every now and then, and it is not in the interest of the child. And that's why I said that for us, we have to do more. Domestic violence and family breakdown. Children are exposed to this, and they become invisible victims within family proceedings. They experience psychological trauma, disrupted schooling, and secondary victimization. It happens a lot, and at times, the fight between the parents becloud everybody, and they forget that when two elephants fight, the grass would actually suffer, and the children will just be there, and the major thing will be the fight between the parents, and the children are suffering. And these children grow up to be children with funny, challenging personalities, and people are wondering why they have grown up to be that, not knowing what they have been exposed to at the family setting. Talking about cultural silence around child abuse. Many communities, abuse remain underreported because family matters are treated as private, and children are often pressured not to testify against relatives. And there's usually a thin line between corporal punishment and abuse. And that's why some schools, especially private schools, have said no corporal punishment, because some teachers don't know when to stop. Even some parents don't know when to stop. And there's this cultural silence about it, because children are regarded as the insignificant member of the family, which awareness is gradually helping to change this narrative. There's limited specialized family courts. As a matter of fact, very, very limited, because most of the time, you just have one or two courtrooms designated as family courts, and so many matters coming up before it. And I'm sure that in many jurisdictions, before you can have a breach of contract matter, you would have seen so many family issue matters. And I don't know why family courts will just have like one or two courtrooms, and the other courtrooms will be for some other businesses. This affects the children. Inadequate social welfare infrastructure. The family justice requires strong welfare institution, but many are underfunded. That underfunding, it's a plague. It's a plague. And economic and social and cultural rights are such that, they are progressively realizable in courts. And that is under the clause where governments usually hide when they don't want to be fully responsible. It said, oh, it's progressively realizable. But there's some basic minimum which government should do, to make the life better for these children. Then child marriage and harmful traditional practices. I cover my face to say that we still have some child marital practices in some regions, and harmful traditional practices continue despite legal prohibition. These practices remove children from legal protection prematurely. Talking about education, young offenders are often deprived of education. And in spite of the fact that, well, they are not sentenced to death, they are put in correctional facility. Some of our correctional facilities are not lack proper access to tailored educational services. And to avoid relapsing into criminal activity, these children must be equipped. Then low literacy levels among young offenders severely impact their future, and most likely make them there's increase in likelihood of reoffending. Poverty is a major challenge. It's a significant strain on children's rights in Nigeria because of pervasive poverty. Many children live in an environment where exploitation and abuse can flourish. It undermines their rights, and some of them are not even going to school, and it creates a perfect sum of challenges that impede progress in child advocacy and protection efforts. In conclusion, ultimately strengthening the Nigerian family justice system requires more than law reform. We need political will, institutional accountability, increased funding, with a shift towards child-focused justice. And the child must not merely be seen within the system, but must be heard, must be protected and prioritized. And while Nigeria has made significant strides through legislative framework like the Child Rights Act, the alignment with international standards, gaps in implementation, institutional capacity, and cultural dynamics continue to limit the full realization of children's rights. The future of family justice in Nigeria lies in bridging this gap between law and practice, ensuring that every child, regardless of circumstance, experiences justice not as an abstract ideal, but as a lived reality. I want to appreciate the BNF for this opportunity, particularly Mr. Babs Akinyoju, for this opportunity to have this little say. Thank you.
Thank you very much. Thank you, Professor Olomola. I mean, when you were highlighting the challenges of family justice in Nigeria, I'm sure Maria Wright too might agree with me and some of the participants that there are similar challenges that children face in the family courts in England and Wales. Of course, one should appreciate that, population-wise, it's quite significant between in England, it's a total population of roughly 65 million people, whereas Nigeria is 230 million, of which a significant number of the population is under the age of 18. And then, given as you said, the not only the cultural, but I think the geography of of Nigeria as well, and its diversity that also um, has its own challenges in terms of running an efficient family justice administration. But no, there are a lot of pointers that I think one can explore further when we get to the Q&A. So thank you very much for that. And I think that moves us really into Dr. Wright's presentation, which is about what happens when the court determines or is deciding how children may be placed with families abroad. So thank you. Over to you.
Thank you so much. And thank you so much for the invitation to speak today. And such an interesting presentation from Professor Olomola earlier. I hope that some of the matters that she discussed I can pick up on in my presentation. So just to introduce, I hope everyone can see the slides. My name is Maria Wright. I'm a solicitor at Hunters, and I also did a piece of doctoral research looking at care proceedings with an international element. And what I'm talking about in this context is cases where children are the subject of public law proceedings in England and Wales. So these are cases where a local authority believes a child may be at risk of significant harm. And in these circumstances, the court must determine not only whether the thresholds for state intervention is met, but also, crucially, what kind of placement is in the child's best interests in the short and long term. And this typically involves asking a number of questions. Should the child remain with their parents who may have subjected them to abuse, maltreatment, neglect, or should they return to the care of their parents? Is that safe? Should they enter long-term foster care? Should they be placed for adoption? Or should they be placed with extended family members, what we would call kinship care? Is this in the child's best interests? So where possible, the law is clear in England and Wales that family placement should be explored for children who can't live with their parents because it's not safe. But where a child has international connections, answering that question about how a child can go and live with their extended family overseas can become a really complex question. And so I'd like to share with you today some of the findings of my research in looking at this issue. So firstly, as an introduction, you'll see here a few news articles which were published around 2014, 2015, which was the time I started getting interested in this topic. And what was happening was that there were several high-profile cases in the High Court and the Court of Appeal in England involving children who were foreign nationals. And in many of those cases, overseas state authorities, particularly at that time EU countries, were raising objections to the adoption of foreign national children in England at the end of care proceedings. And essentially what these overseas state authorities were saying is that the English courts were not properly considering whether, firstly, they had jurisdiction over foreign national children to place those children for adoption at the end of care proceedings, but also that English courts and local authorities were not cooperating with their counterparts overseas to explore family placements, and instead were rushing into adoption when there were viable family placements overseas which should have been explored and should have been assessed. Next slide, please. So these cases led to what I would describe as a cascade of guidance, which reshaped how we look at these public law cases with an international dimension. And this guidance forms the backdrop for some of the findings I'll speak about in a moment. But a number of core principles emerged from these controversial cases. Firstly, that courts need to address the issue of jurisdiction right at the outset of proceedings where a child has international connections. And where appropriate, it should be, consideration should be given to transferring that jurisdiction to a country that the child has a connection with. There was also an expectation that local authorities and courts, to an extent, would notify the relevant embassy if care proceedings were issued concerning a foreign national child. But crucially, one of the core principles from this guidance was that UK social workers were discouraged from travelling overseas to conduct assessments of family members in other countries as potential carers for children who were in care in the UK. That was a practice that had been happening quite a bit. UK social workers going to Hungary, going to Poland, going to countries outside of the EU, visiting family members who had said they could care for a child, producing assessments. And that practice was really discouraged. And instead, there was an emphasis on cooperating with professionals in other countries to produce these assessments. And really, the legal route for doing that primarily was through instruments of private international law. So now we have the 1996 Hague Child Protection Convention, which gives us institutions, central authorities, who we can cooperate with where there's a potential family member in another contracting state to the convention. But when we're looking at potential placements in countries like Nigeria, we don't have that institutional framework and we don't have those kind of bilateral instruments. So the emphasis is on cross-border cooperation with professionals in those countries and children and families across borders. CFAB, the International Social Service Network, is one method for doing this. So this guidance kind of emphasised the need to look to local professionals to assess family members overseas and to get assessments which were culturally relevant as well as being legally compliant. Okay, next slide, please. So when I did my research, what I did was I looked at 100 care cases which all had an international element, and I analysed how those cases worked in practice, and I also interviewed social workers and I interviewed lawyers who had experience in this area. And of the 100 cases that I looked at, 91% involved a child who had a parent or a relative overseas who needed to be assessed as a potential carer for that child. And often there was more than one relative overseas. However, what I saw was that there is no single consistent route for commissioning these assessments. Instead, there's a kind of patchwork of different methods which are used. The most common approach was for a local assessment to be commissioned by a professional in the country where the child would potentially be living. And this was consistent with the guidance that I've just mentioned. But what I found was that in nearly 40% of cases where there was a local assessment, there were criticisms by UK judges or local authorities of the quality of that assessment. And what that meant really when there were these criticisms of quality is that the local assessments conducted by social workers in other countries did not meet the criteria that we would use in this country for assessing family members as potential carers for children. But the knock-on effect of this was that you would have your assessment conducted by a social worker in another country. It would come back, everyone would look at it and say, this doesn't meet our criteria. And then a further assessment would be commissioned, usually by a UK social worker. And this whole process caused a huge delay in the determination of these cases. And they were taking much longer than the national average. The average length of proceedings where a potential carer overseas needed to be assessed was 43.6 weeks, compared to a national average of 29 weeks at that time. Next slide, please. So what we can say is that there is a fundamental tension here when we're looking at assessing family members overseas as potential carers for children. On the one hand, in England and Wales, we have these domestic regulatory frameworks for assessing family members, which require us to meet certain criteria, require us to look at certain things to decide whether a potential placement is in a child's best interests. But those frameworks were not designed for cross-border family relationships. Cross-border family relationships will necessarily have very distinct features compared to family relationships where everyone's in the same country. And the other factor to bear in mind is that there is a huge global diversity in child protection practice. In many countries, kinship care is not a regulated response to child neglect and maltreatment in the same way that it is in the UK. In many countries, kinship care is an informal practice which is not regulated. And also the way child protection services operate in countries across the world is also extremely diverse. And the extent to which the state will interfere in situations where children are exposed to abuse and neglect also varies hugely around the world. So this is the fundamental tension that we encounter in this context. The result of this is that UK professionals often end up trying to fit cross-border family relationships and cross-border family structures into a domestic regulatory box, and that can distort the process and the outcome for the child. Okay, next slide, please. So one quotation from one of the social workers I interviewed, I thought summed up this tension and the potential risks of this approach. She said to me, if we can get one of our own social workers out, we have more confidence in those assessments because they know the child, and where the assessments have been done by us, the child is more likely to move to family overseas. So she expressed to me a strong preference to English social workers assessing these families overseas as potential carers for children who are in care in the UK. And not only that, a correlation between the success of that placement actually happening when it is conducted by a UK-based professional. So here we have a bit of, a bit of a concern being expressed by a social worker in this country about having confidence in an assessment conducted by a professional overseas. And I think this can be quite worrying. The danger of this mindset is it may lead to overvaluing domestic assessments and undervaluing local expertise overseas. And if you could move to the next slide, please. In this case example, we can see how this might play out in practice. So this is one of the cases that I looked at as part of my research. it's anonymized, and the country concerned is also removed to prevent the case being identified. But in this case, maternal grandparents lived in a West African country. Early in the case, they were effectively discounted as potential carers for the child because the local authority conducted an initial viability assessment of those grandparents by phone and by email, and concluded that they were not going to be appropriate carers for the child. And that was challenged in this case, and the judge didn't accept that and ultimately did order a full assessment of those grandparents. But the social worker, UK-based social worker who had conducted that initial assessment, conceded that the assessment she had done lacked the rigour which she would have applied had the grandparents been living in the UK. And ultimately, in that case, what happened was a social worker based in the country where the grandparents were living conducted a full comprehensive assessment, which was culturally relevant. And the child was able to go and live with those grandparents. So we can see here how important this issue is, because the alternative outcome for that child would have been a placement in long-term foster care in England rather than a placement with family. Next slide, please. Have we moved to the next slide? Sorry, I can't see that we have.
We have. So the next slide says one of our own continues from
Case 32?
Yes, case 32.
Okay, sorry, it's not moved on my one, but that's fine. So case 32 was a similar theme. Here again, we had a potential carers in a West African country. A local authority, a local professional completed an assessment through Children and Families Across Borders, which was positive, but the local authority in the UK felt it was insufficient, particularly around the question of risk management. So how would the family members respond to situations where the child was placed at risk? And a further UK-style assessment was attempted, but it turned out to be negative, largely because of an absence of information from the other country. And because of this absence of information, the local authority changed its care plan to adoption. The children's guardian disagreed, and ultimately the court did place the children with those relatives overseas. But what is interesting about this case is that the perceived inadequacy of an assessment, having gaps in information, was considered so crucial that it had the potential to mean that the child could not go and live with those relatives. It was nothing to do with their ability to care for the child. It was about the extent to which the court had the relevant information to make that decision. Okay, if we go to the next slide. So across the sample of cases I looked at, only 15% of children who had potential kinship carers overseas were ultimately placed abroad with those carers. And most of those children were babies or infants. And around 80% of those children had experienced an interim separation into foster care before that final decision was made. Those proceedings where children were placed overseas at the end of the case lasted on average 54 weeks, so more than a year, which was nearly double the national expectation at that time. So these were really complex, really delayed proceedings where generally babies and infants were going to live in foster care for a lot of their lives before transitioning to go and live with family overseas. So you can see from the child's perspective what a challenging situation that might be if it's not appropriately managed. So that was kind of the core challenge of these cases. The other issue that arose is a bit kind of similar to the way that overseas assessments were conceptualized. There's a really strong emphasis on placing a legal framework around these overseas placements, which mirrors exactly the way that we in England regulate these placements. So we have special guardianship orders and we have child arrangements orders in England as a way of ordering these placements, giving the carers parental responsibility. Often these can have quite specific provisions. And the kind of drive in the cases was to replicate that as closely as possible in the country where the child was going to be living. So overall, we can see that these cross-border assessments and cross-border placements were framed in domestic terms. We have English courts and English local authorities effectively trying to replicate what we do in this country in other countries without really thinking about how the legal system works in that country, how kinship care is regulated, what the approach is to kinship care, how the child protection system works in that country. It's almost like trying to impose a way of ordering these placements on countries, other countries, irrespective of how the matter would be dealt with in the country where the child, after all, is going to be growing up and spending their childhood. Okay, so that brings me to the end of my presentation. The fundamental issue which I encountered in these cases when I was analysing them from my research is that in England and Wales, what we are trying to do is to fit cross-border family relationships into a domestic regulatory framework that was not designed for these relationships. And when we do that, we risk prioritising legal compliance over the child's lived experience, their relationships, their identity, their language, their culture, the nature of care in the country where they're going to be living and growing up and calling home for the rest of their minority. And what we really need to do is to take a more child-centered and individualized approach to these cases. We need to recognize the limitations of our domestic law and how it doesn't necessarily promote the best interests of children with international connections. We need to value local assessments and expertise for the cultural and contextual insights that they will offer. We need to reduce the delay in these cases and be a bit more realistic about the assessment process. And ultimately, we need to stop trying to fit these cross-border family relationships into an English legislative framework, because this doesn't reflect the reality for children with international connections. Thank you very much.
Thank you very much. Yes. Oh wow, that's there's a lot in there. In fact, I can recollect this was quite a few years ago when I used to work at the East London Family Court, and there's a public law case. I think it might have involved a Nigerian child, and the issue of the social worker traveling to Nigeria to do the assessment. And what's interesting is that the local authority social worker was actually of Nigerian heritage.
Mm-hmm.
So I think it was like I think that social worker was looking forward to it in terms of, yes, the work has to be done, but also the opportunity to go and reconnect probably with friends or family in Nigeria. But I think probably cost was an issue that didn't happen. I don't know how the case concluded, but I mean that becomes an issue because local authorities are extremely stretched with their resources. But no, thank you for that, because just to explain, the SGO special guardianship orders and child arrangement orders. as I say, from the English law perspective, they give the um, kinship carer, so the carer in the overseas country, that kind of parental responsibility, parental rights until the child is 18. But what happens then when that child becomes 18? Out of interest. What-
Um, well, that's a good question. So, these orders only regulate the parental responsibility for the child under 18.
Mm,
So then, because these are not adoptions, you know,
yeah,
these don't create new family relationships. They're just effectively a way of ensuring that the child has someone who is able to make decisions for them and promote their welfare when they're vulnerable and they need that help. Um, one of the issues that I looked at a little bit in my research was what happens if these placements overseas break down. So if you have a child who's placed with a carer in another country and then a year later it all falls apart, what then happens to the child? Because quite often what you will find is that there will be a wish to send the child back to the UK. And then the local authority in this country will say, this child's no longer our responsibility. So it can become very complex, or the alternative is the child going into a state care system overseas, where they have no connections other than that family member.
that's right. Yes. Yes. I can see as a question here from Kiadego. I think it's directed to Professor Olomola. If a court in Nigeria gives a maintenance payment order and the father does not oblige, what recourse is available in Nigerian law and UK law, considering the child is based in the UK? So, if I just break this down, I guess at some point the parents were maybe living in Nigeria or got married in Nigeria, and I would take it that the mother and child are now living in the UK. So it would be enforcement of a maintenance order, enforcement of a Nigerian maintenance order, um, and how that can be achieved. Yes, I think I know the answer from UK to Nigeria, but this is an interesting question in that I suppose if the maintenance order is made in Nigeria, how is it enforced
You
in the
know,
UK?
it's a very tricky one, because even for um parents that are in Nigeria, it's actually very difficult to get this, because like I said, income may not be as traceable as in developed economies. So, most of the time, what happens is that they try to get them arrested, get them threatened. I mentioned that it is one of the major issues. And now crossing the border to another location makes it much more complicated, because it may be, I don't know, whatever the court has made the order, except there are things where they can attach the account,
Mm,
the account of the father, They are trying to do that now, even for breach of contract cases. If you're able to lay your hand on the BVN or whatever, can attach the account. But what if the person does not? But it's difficult to actually transact without accounts nowadays, and BVN is connected to all accounts. It might be only through that source, but sincerely, to get a parent to do that may be very difficult. May be very, very, very difficult. I don't know from England to Nigeria, but it is a Herculean task, because even for parents that are living in Nigeria, we do a lot of things to get parents to pay. We get bench warrants, they arrest the man, they that try to attach the account directly. Some will claim that they have lost their job, so they don't have money again. And people can even get money through their family members' accounts, especially when they have issues with the wife. He can be telling, if he's a businessman, he can be telling them to pay to another account, that does not bear his own BVN, and it may not be traceable. And that is one of the issues that we have in enforcement of orders, especially in Nigeria. We have laws, but I think that we have to just be more proactive and look at the issue of BVN, and try to clear up some of those things at the point of filing, so that the court will not become a toothless bulldog. But sincerely, to get that, except they can get an order to attach the bank account of the man. I doubt if and they can establish before the court that, oh, he has this and has that, which may not be deniable anyway, but it can also be deniable. That is the only instance I see that they can able to do that trans-border or cross-border.
So BVN, that is the bank verification
Application
number.
number, because if you have several accounts, it will be same number.
Yes.
But I said that they can short circuit that system by not using their own account to receive payments.
All right.
You know,
Yeah.
and a lot of things do happen.
Yes. And also assets as well, property, if that is traceable.
Yes,
Is
only
that
traceable.
property?
I know of a particular matter where the man rushed to sell his property in US. The only one he couldn't do was the one in UK. And that was the only one that was able to recover for the wife and the children. The ones in just went and, they were living in Canada before they had issues. He collected his equity on the property without the wife's knowledge. So he did several things. And he was banned from entering Canada. He got to Nigeria. Of course, he went to US, sold off the property there. But the UK, the wife was able to put a lien on the property. And then to get the man to pay throughout, the man has passed on now, but throughout, and the children are gradually maturing, but throughout was really, really difficult to get anything from the man, because the asset that they could easily lay hands upon, he liquidated them before. And anybody that wants to do all those things, they are always very wise and fast about what they want to do, especially when they see that they're already having issues in their relationship. And that's where I concluded that most of the time, when two elephants fight, is the grass that would suffer. So we need to be more searchlight on the children. They fight, and at the end of the day, the children will be at the brunt.
That's right. Yes. Yes. I have another question from Ifiu Chendu. Is there a corresponding law, for example, in Nigeria, to place a child from Nigeria with an extended family member in the UK? So, in fact, the procedure that Maria was speaking about, if for and I'm not sure we have. Okay, if under the Child Rights Act, for example, and it is found that the parents are unable to care for the child, we'll say through abuse, neglect, and so forth. But there is a relative in the UK. Um, are you aware of a procedure where, that child could be placed in the UK, that kind of assessment from a Nigerian law point of view?
What happens in Nigeria for such situation is that the family in UK would apply for adoption.
Okay,
That child will be adopted.
okay,
And if it is in the best interest of that child, and since it's a near family, of course, the welfare, the social welfare office would assess the situation, but the person would need to come around to Nigeria because there's some basic things that they will need to do, before the child is. I've seen situations like that where a child will be taken over. There was a lady, a single parent, and a single parent all along, but if eventually passed on, and the child was just on her own with different families, but the sister abroad decided to adopt and take her over. It's very possible, very, very possible
yes,
that but it's through adoption. No placement order, they would rather do within a certain way because they place a lot of premium on monitoring, you know, to play the supervisory role. And that is why transborder adoption, they do it. They do it, but it takes time. They want to assess the people that want to take over the children. But you see, this one is for child's in the best interest of the child. Of course, they will not close their eyes to that because a family relative may be better than just leaving the child suffering needlessly. Yeah, they could adopt. And once it is in the best interest of the child, that's why I said it's a case by case analysis. They look at the peculiarities in each case before a decision is made concerning that particular child. Because what works for A may not work for B. And they have to be sure that indeed they are taking the child over for adequate, and it might even get involved with some of the things, some legalities in the country, in the other country, because they want to be sure that it's not going to be another case of modern day slavery. They want to be sure that
yes,
the
yes.
child is being taken over for proper care.
Yes. Yes, there have been, unfortunately, issues like that. Not least the Victoria, Columbia, who tragically came to the UK and was actually murdered by her family members.
Hmm.
Actually, Maria, do you deal with foreign adoptions into the UK? Because one issue with adoptions from Nigeria, there's the immigration
Yeah.
slant to it.
Yes, I think that's all I would add is that often there is an immigration challenge with those intercountry adoptions. I think and actually, I have only really seen with Nigerian cases it happening with intercountry adoption of a child being placed in this country. Sometimes when you get, what's interesting sometimes is that where a child in another country needs to be placed with relatives in this country, not by adoption, but just by a kind of family placement, you will not experience the same kind of proactive work by local authorities in this country to assess that placement and to provide information, because the idea would be of local authorities here, as you say, being strapped for cash. Why should we assess this family in relation to a child who's not even here and who is not our responsibility? But when you're looking at placements going the other way, there's an expectation by courts and local authorities here that overseas state authorities will be extremely cooperative and do everything they can to provide that information. So it's not necessarily reciprocal. But yes, I would certainly say that primarily I see that in an inter-country adoption context.
Yes. It was actually a topic that we covered at the seminar we had last October, where one of our colleagues, Abimbola Badejo, talked about inter-country adoption and the restrictions that there are.
Yeah.
Yes, thank you. Fumbi, I think this is your cue. So you have 3 minutes left.
Yes. Hi, everyone. Thank you so much for joining us. Thank you to Professor Omolade and Dr. Wright for joining us today. Really insightful. Thank you, Mr. Kinyoji, for hosting and guiding us through this conversation. For everyone who's on the call, thank you for joining us this evening. I am Funbi Akinsanya, and I serve as social secretary for the BNLF. And thank you for joining us this evening. For anyone who's unaware, we have a few events coming up in the next couple of weeks. As we approach April, we're going to be having our spring networking drinks in London, happening at Fleet Street Lazy Ballerinas on April 27th. Tickets are now available. If you are a paid up member of the BNLF, you might be a shoo-in to win a complimentary ticket. So the first 10 members who send us an email info@bnlf.org.uk, you might get a complimentary ticket. Once those are gone, you would have to purchase tickets via our Eventbrite. And in June, we are having our Nigeria Summit 2026. We had the inaugural summit last year, and we're back in Lagos again this June 26th and 27th. So if you are in Lagos or you're planning to come into Lagos during the summer, please join us for that summit. The theme this year is A New Dawn, looking at UK Nigeria investments and cross-border collaboration. All in all, I just want to say thank you once again to all our speakers, to Katie Deans, and the support from our Family Wizard for what it does with the family law group here at the British Nigeria Law Forum. Once again, thank you, everyone, and I hope you have a fantastic evening.
Thank you. Thank you, everyone.
Thank you.
Thank you.
Good evening.
It's been a
Bye.
good one. Good evening.